Good morning. Welcome, Ms. Oxley.
Thank you.
We see you have a guest today. Would you like to introduce your guest?
I do. This is Randy, my husband. He drove over with me from Cedar Rapids this morning.
Wonderful. Thank you. Thank you. Well, it's good to have you here today. You may begin when you're ready with your opening statement.
Okay, thank you. First, I would like to thank you all for your service on the Nominating Commission, which I think is a very important part of our judicial process. I don't think I realized how much work goes into being on that side of this table until I got involved in this process, so I thank you. In one way, I would prefer not to be here at all, that none of us were here. And that's because Chief Justice Cady's passing is a huge loss to the court and to the state. I think we all expected the Cady Court to continue for a good number of years. His legacy was not yet complete, despite the many wonderful things that he did. Not only the numerous opinions that he wrote, but his work in taking the court on the road, helping establish and expanding the state specialty courts, and just bringing dignity and respect to the judiciary. But the court's work must go on, and I'm humbled to sit here today to be considered as one of the nominees for the vacancy that he left. Several days after learning of Justice Cady's death, it was actually my husband who asked me if I would consider applying for his vacancy. Being an appellate judge has long been a dream job, as he well knew. And so when he asked me that question, I gave it a long, hard look. Applying to be a Supreme Court justice is not something that I take lightly or a position that I seek cavalierly. I have a great deal of respect for the institution that is the Supreme Court of Iowa. Having taken that hard look, though, I think that my background, my legal experience, and my demeanor and character would make me well suited to join the Supreme Court. I consider myself an Iowan, even though I was born in southern Missouri. We moved to a farm outside of Greenfield, Iowa when I was 11 years old, and my dad managed a 400-head cattle operation. I didn't realize how lucky I was to grow up with 1,800 acres of Iowa farmland as my background, or as my backyard. But I was a farm kid through and through. I drove a tractor long before I could drive a car. I showed horses and rabbits at the county fair. My parents instilled a strong work ethic in me and my two siblings. We worked hard, but family time and fun were also just as important once the work was done. My parents always expected us to do our best. Following our interests and making a difference were more important, though, than the paycheck or the accolades that came with the chosen career path. There were no attorneys in my family. I don't really even remember knowing any attorneys growing up. My first interest in law school came from a business law class that I took as part of my accounting undergrad at UNI. My first job out of college, where I traveled around the state auditing credit unions and enforcing the regulations, gave me another taste of the law. My husband started a gutter business when I was transferred from Des Moines to Cedar Rapids, and so my focus was on helping him build that business. We thought it was also a good time to start a family, but when that was not successful, applying for law school kind of did the trick. A week after I got accepted, I found that I was pregnant. But so I finished law school. We continued working to grow his business and raise our family. I loved the legal challenges that I got to experience during my one-year term clerkship with Judge Hanson. And then I worked hard to learn the practice, how to be a practicing attorney when I joined Shuttleworth and Ingersoll after that first year. But when Judge Hanson asked me to return a couple of years later as a career clerk, I accepted the position, excited to return to the world of appellate law. We found an 18-acre chunk of farmland outside of Cedar Rapids where we built a hobby farm, complete with horses, dogs, and at times goats and chickens. Our kids attended Trinity Lutheran School in Cedar Rapids. It's a Lutheran elementary and middle school. I appreciated the values and the strong education that they received there, and I became pretty involved in the school, both as a volunteer and as a member of the school board. I served 2 terms as chair of the school board, and I continue to serve on the board even though it's been 8 years since our youngest graduated, because I really believe in the values that it brings to the Cedar Rapids community. I tell you my background because I think it's important for you to know who I am as a person outside of my law practice, so you can see how that affects me inside my law practice. My law career has always been important to me, but it has been balanced with running a business and raising a family. I debated legal issues with Judge Hanson and my co-clerks during the day, and then I retreated to our farm and our busy kids' lives at night. Serving as Judge Hansen's confidant for 10 years gave me a valuable insight into the inner workings of a collegial appellate court. Judge Hansen did not always agree with his colleagues, but I witnessed firsthand judges who were able to disagree while respecting each other's views. The judges, all of them, often went to eat at Tony's, their favorite St. Louis steakhouse, in the evenings after conferencing about cases where they did not always agree. This reinforced in me the importance of other people and their views. One of the struggles with society today, I think, is the inability to listen to other people's views, to other people who have a different view than you do. I've learned through my practice the importance of being able to listen objectively. There are always two sides to any issue. Things are not black and white. Life is lived in the gray areas and the nuances that you can't really appreciate unless you are really committed to digging in deep into the issues with an open mind. So one thing I took from my work at the appellate court into my private practice, was the ability to look objectively at all sides of an issue. This helped me identify and then address the weaknesses in my client's position. You have to allow your position to be tested to know if it's really going to hold up. And the way you do that, I believe, as an appellate judge or justice, is to listen openly and objectively to your colleagues' opposing views, and allow them to test your own views. I also learned while working with Judge Hansen the art of judicial restraint. While legal issues may have lurked on the edges of a case that were more interesting than the ones that were brought in the parties' briefs, our adversarial system works best, I believe, when lawyers are allowed to bring the issues that are most important to their clients to the courts, and judges restrict themselves to deciding those developed factual and legal issues. Get it right, keep it tight, not only guided my work in drafting opinions for Judge Hansen, but I believe it serves as the approach a judge should take to every single case. Certainly getting the resolution right is critical to the parties that are before the court, but also to future litigants. But not only is getting the outcome important, also the reasoning and providing clarity in the way that reasoning is presented in an opinion, so that future litigants will know the law as well. Keeping it tight means being committed to the court's role in a democratic society, where the judiciary is tasked with deciding cases and interpreting the law as the legislature has drafted it, not setting policies or imposing their view of what the law ought to be. It also means being wary of both the intended and the unintended consequences of the words used in an opinion. Once the draft was close to complete for Judge Hansen, we went through the draft sentence by sentence to consider how it could be taken out of context or used in a way that was not intended by its analysis. When Judge Hansen took inactive status, I returned to Shuttleworth intent on developing a strong appellate practice. I was able to do that with the support of my partners, who brought me into their more legally complex cases at an early stage of the litigation. This helped ensure that the legal issues were properly considered at the beginning and throughout litigation, and to ensure that we developed the strongest factual basis to support our legal position. This holistic approach to my appellate work allowed me to focus on the complex legal issues while also gaining significant litigation experience both in and outside of the courtroom. When I sat down to compile a list of the number of appeals I had participated in as part of answering the questions for the application, I was a bit surprised that I had actually worked on over 24 appeals in the 9 years that I've been back in practice. One thing I appreciate most about my appellate practice is that because my specialty is appeals, I'm actually more of a generalist when it comes to subject matter area. So whereas many of my partners specialize in medical malpractice or employment or trust and estates or construction law, I've been involved in almost every area of law that our firm has handled. I firmly believe that Supreme Court justices should have the legal acumen and the experience that is needed to address the significant legal issues that come before the court. But those are just qualifiers. Those are not the deciding factors. An individual's integrity and their demeanor are important to being a successful Supreme Court justice. Integrity in the form of being true to the process and true to the role of a justice, and demeanor in how one treats others, both from the bench and in private. Compassion is another attribute that I think is important for the Supreme Court. I chose to develop an appellate practice because I love studying the law and digging into complex legal issues, but not just in the abstract. That's what law review articles are for. The time I have spent in practice working for my clients has really driven that home to me. Clients want you to fix a problem or settle the dispute, and they don't really care what the legal steps are that you have to go through under a particular legal doctrine. So while I love the intellectual challenge of researching a legal issue and writing about it in a persuasive way, I do that in the context of how the outcome affects a particular situation and the individuals that are involved in that situation. As a justice, I would do that with a focus toward bringing clarity to the issue at hand and communicating it through the written opinion so that the next person knows what to expect. Intellectual honesty is another important attribute of a Supreme Court justice. I have tried to instill in my kids that if you can only win by cheating, then you don't really win. That same general concept applies to practicing law and especially to judging law. When drafting opinions for Judge Hanson, I recall instances where an opinion simply wouldn't write. And by that I mean when you sat down and really went through the analysis, you simply couldn't get to the result that the panel had recommended without twisting the analysis somewhere along the way. And I don't mean to imply that Judge Hanson or his colleagues were result-oriented, very much the opposite. But sometimes the parties' briefs and arguments would miss a step of the legal analysis or ignore or fail to consider a caveat of a legal rule or maybe ignore or misstate some of the facts. And when that happened, we would draft an opinion that followed the analysis that was true to the legal doctrine rather than the proposed outcome by the panel. And on more than one occasion, Judge Hanson was able to convince his colleagues to change the outcome of the case. I've tried to give you a flavor of who I am as a person and as a practicing lawyer. In closing my remarks, I simply want you to know that I don't have an agenda for applying for this position. I guess what you see is what you get. But I hope that what you see is someone that has the experience and the personal qualities to make a difference on the Supreme Court. Thank you.
Thank you. And so we'll have some questions now. Mr. Spies, would you like to begin?
Thank you. Good morning, Ms. Oxley.
Good morning.
When you and I met, I confessed readily that I was a big fan of Judge Hanson's. I still hear ringing in my head his comment from the bench. Mr. Spies, I can tell by the look on your face you didn't expect that answer from the witness. You've had a unique opportunity to see the judicial process up close and personal. And how was Judge Hanson able to navigate disagreements with his colleagues, and what did you learn from seeing that in him?
Sure. Judge Hanson was a great mentor. I think respect for his colleagues was probably the way that he did that the best. He was always very respectful of his colleagues' opposing views, very patient in listening to their view of an issue, and then being very respectful when he disagreed with it. He tried to persuade through the analysis that we used in an opinion, rather than through talking louder, about faster or longer. So I think that that's something that I certainly learned from him, and I value. I'm just not a person who. I see every person has value, and the fact that someone disagrees with you doesn't mean that it needs to be personal. And so I learned from him, and I take from him that having differing views doesn't mean that you can't like each other or get along outside of that. But I think it also allowed me to see and often saw him really, if someone had an opposing view, then he would really dig into his own view to make sure that he was right about it. So he wasn't so tied to his own view that he would disregard someone else's view just because it was different than his. So he really wanted to get to the right answer, and if his wasn't the right answer, then he was willing to recognize that if the proper legal analysis supported that.
Thanks.
Thank you. Mr. Blum, do you have a question?
Yes, I do. So when I read your application, it was the first time, I'm not a lawyer, so I wasn't familiar. I'd not seen a person with a resume like that had a long time as a career law clerk. So I Googled that just to learn a little more about it. And the first thing that popped up was Law Clerks Gone Wild. So that turned out to be not as interesting as I thought it was. It was an example would be there was a jury asked for rereading of testimony, and they couldn't find the judge in the building, so the law clerk stepped in and authorized it. That unleashed a whole avalanche of problems. So that was more the intent there. But in your experience as a federal law clerk, you indicated that about half of your cases were criminal related, and there is a legitimate argument that we need stronger criminal background on our Iowa Supreme Court. So could you comment a little bit on that experience and how it would fly?
And I would say that criminal law is well over half, probably 60% of what a federal judge sees. And I agree that I think that in Iowa, probably most practitioners are either practice in civil or in criminal law. So the experience that I had spending 10 years with Judge Hanson on the court, I saw a huge gamut, and it was in federal court, but it was very similar to the kinds of things that I believe that the Iowa Supreme Court sees. Certainly to the extent that there are constitutional challenges to a sentence or to a conviction, the habeas corpus relief that the prisoners often seek, but also challenges to the criminal statutes, search and seizure issues. And I was also there long enough actually to see some kind of repeat issues where a criminal defendant was convicted, and then they were eventually let out on supervised release, and then they failed to follow the supervised release, so they were back on something, and see those appeals. And so since I have never practiced in criminal law, I actually did find those cases probably the most interesting to work on when I was with Judge Hanson. And I think partly because someone's liberty is at stake, and so I think that they're certainly much more important from that perspective than some of the business disputes that I represent my clients now. Obviously, it's important to them, but at the end, that's just money. And so I certainly saw those, and they were very interesting cases to work on, and I enjoyed working on them. And I recognized, that is an important area, and people's liberties are very important. So I do think that experience that I have will help in that area.
Okay, thank you.
Thank you. Ms. Stanger?
Thank you. Good morning.
Good morning.
This kind of goes along Mr. Gray's earlier questions. One of the roles of our Iowa Supreme Court is, of course, the opinion drafting, but another significant piece of it is the administration of justice. And servant leadership is a significant part or a value and a mindset that I have applied for years. One of the things I'd like you to talk to the commission about is your experience in leadership and servitude, and you certainly have tenacity. Anyone who takes a final exam after delivering a baby is like on a podium to me already. So you've demonstrated academic strength, tenacity, fierceness, unlike many candidates. But what I'd like you to share is more about your leadership experience in administering and how that would bring to the administration of justice in Iowa.
Okay, I think my most significant leadership experience is probably my work. Actually, I've been chair of a couple of different things. Trinity Lutheran School in Cedar Rapids is one of those. I was chair for 2 terms, so 4 years, while being on the board. And as a private school, we just went through a lot of different issues. We had some principal changeover in principal that left, and so we had a vacancy, and trying to administer the school and run the school during that time when we were trying to find another principal. There are always budget issues with a private school for sure. I was blessed to have a very strong public education system, which is great for the state, but if you're trying to run a public school or private school, that actually is a little bit of a disadvantage to convincing people the value of that school. So budget issues are something that I've worked with for a long time through the school. I also, the 8th Circuit Bar Association, is another area where I have served as a leader. I was on that board for a number of years, and then I got onto as kind of a ladder to work towards being the president. So then I served as a treasurer, and then the president, the vice president, and then the president. And then so in that organization, it's kind of, there's lots of different kinds of bar associations, and so with that one, we really tried to make it purposeful, I guess, to the members through CLE programs and things like that. But we also instituted, during my time, the Richard S. Arnold Lifetime Achievement Award that the 8th Circuit at its judicial conference that's held every year actually recognizes an attorney from each of the 10 districts within the 8th Circuit for attributes that are similar to what Richard Arnold would have held. And so that was something that I did while I was on that board as well. Oh, you bet.
Thank you, and I'm very sorry to say that we are out of time, but we appreciate your being here today, and we certainly wish you well.
Thank you. I very much appreciate being here.